On Tuesday, I'll be talking about Snyder versus Phelps, which is a case that the Supreme Court heard a couple of weeks ago. This case pits the tort of intentional infliction of emotional distress against the right of free speech protected by the First Amendment. And it's a case that many commentators are following. It follows the noted earlier case of Falwell versus Flint, in which the court looked at whether a public figure could sue a speaker under the tort of intentional infliction of emotional distress and win damages. In Snyder versus Phelps, the father of a Marine killed in the Iraq War in 2006 sought to bury his son in Westminster, Maryland, brought his son's body for a funeral. A small Kansas-based church, the Westboro Baptist Church, learned of the plans for the funeral and traveled to Maryland to picket that funeral. This church was founded by a man named Phelps, and he sought to organize a protest within range of that funeral, a protest against what he considers to be the United States' over-tolerance of homosexuality, particularly in the military. Now, at the funeral, the church's picketers complied with local ordinances and police directions in terms of where they positioned themselves. And the family members of the slain Marine did not see the signs that were carried by the picketers until watching television later in the day. Returning to Kansas, the Phelps group, the church group, posted speech on their website, www.godhatesfags.com, posted speech on that website which claimed that the Snyder family had taught their son to defy his creator, raised him for the devil, and so forth. That kind of speech was posted on their website. The Snyders ran a Google search with their son's name and found this speech on the internet. So we have a case in which the Snyders are claiming a number of things stemming from the action of the picketers nearby the funeral and stemming from the speech that they posted on the internet. The Snyders claimed defamation, claimed public disclosure of private facts, an invasion of privacy cause of action, claimed intentional infliction of emotional distress, claimed intrusion on seclusion, another privacy claim, claimed civil conspiracy, brought 5 counts against the Westboro Church for these activities, and filed the claim in U.S. District Court. The defamation claim was thrown out. The court felt that the language here involved essentially religious opinion, not the statements of fact that must be a predicate for a libel claim. One of the privacy claims was also thrown out, public disclosure of private facts. The court said there was really no exposure of private information about the Snyders. And so the case went to trial on essentially the conspiracy claim, but primarily the intentional infliction of emotional distress claim and the intrusion claim. At the trial in U.S. federal court, the 3 remaining claims went to the jury, and the jury came back with a sizable award for plaintiffs, something in the ballpark of $11 million. The trial judge remitted the damages to about half of that, about $5 million. And so now the Westboro Baptist Church is claiming that entry of that judgment against the church for $5 million essentially violates the First Amendment rights of right of free speech. The Supreme Court heard this case recently, as I said, and the justices asked numerous questions of both sides about the intentional infliction tort, about free speech precedents, about the Falwell versus Flint case that sort of looms in the background as a relevant precedent. And the court seemed to be very concerned about the plaintiff's emotional distress that took place as a result of these activities, and yet at the same time concerned that the intentional infliction of emotional distress tort is a pretty vague tort, and that when it bumps up against the First Amendment, it creates serious concerns. I think that what's going to be most interesting about this decision is the handling of the damages award by the justices. Does this violate the First Amendment? The Falwell case isn't exactly on all fours with this case because that involved a public figure. And the Snyders here, the plaintiff family here, the plaintiff father here, is probably not a public figure. On the other hand, the speech of the church arguably is about a matter of public concern, about politics, war, morality. And the question will be whether or not the First Amendment protects that kind of speech in the context of a funeral, in the context of the internet, when the plaintiff is essentially bringing a claim that he's been violated by this speech and has suffered severe emotional distress as a consequence. One thing to look for in the Falwell case, the court ruled unanimously for Flint, for Hustler magazine in that case, for the speaker, found that the public figure plaintiff, Reverend Falwell, could not keep his jury award for intentional infliction of emotional distress. The court in that case was very concerned about the slippery slope. If we let Reverend Falwell keep his damages against Hustler magazine and the publisher, Mr. Flint, couldn't that lead other public figures to bring lawsuits against political cartoonists, political satirists, political commentators that really have an edge, that actually do seek to inflict severe emotional distress, or at least are reckless about that? I think the court in the Falwell case was worried about the implications of allowing the plaintiff there to keep his damages. In the same way, the court is going to have to think about whether the Snyders should be allowed to keep the damages that they won against the Westboro Baptist Church. As unappealing and as vile as the speech arguably was, if we let the plaintiffs keep the damages against this speaker, what does that portend for the future? What future plaintiffs might be out there that could bring these sorts of claims against speakers and to claim outrage and emotional distress on the basis of speech? Also, what about this tort, the intentional infliction tort? Isn't it a bit vague in its elements? There's an outrageousness element there, and there's a fear that juries might punish viewpoints by finding expression outrageous in some sense. Is this the proper vehicle for regulating speech, even at funerals? So it's going to be very interesting to see how the court rules here. Will we get another landmark opinion like the Falwell case? Will we get a very narrowly crafted opinion to uphold the verdict in this case? Or will the court go with the Fourth Circuit, and say, no, this opinion, this verdict cannot stand under the First Amendment guarantee of free speech.